Hi, this is Damon Root for Reason Television. I'm here today with Josh Blackman, professor of law at South Texas College of Law in Houston, and author of the new book, Unprecedented. It's the constitutional challenge to Obamacare. Now, obviously, as over the 2 years as the legal challenge to the healthcare law was working its way through the courts, was before the American people, the word unprecedented was thrown around a lot by the challengers. It's an unprecedented exercise of federal power. It's an unprecedented attack on the individual citizen. What made you choose this title for the book?
Well, the Obamacare law was very much a first in several respects. It was unprecedented in that never before had a law been passed of such magnitude that any Republican bought in. It was unprecedented in the fact that never before had Congress forced people to do stuff. It was also unprecedented in the way in which it was passed, kind of ramped through at the last minute without deliberation. Randy Barnett, a law professor at Georgetown, who was one of the leading architects of this challenge, kept using this word over and over again to say that this law is unprecedented, that Congress had never done this before. And at an event, I made an offhand comment to my blog saying, hey, we should have a Randy Barnett drinking game. We take a shot whenever Randy says unprecedented. And if we did that, we'd all be drunk on the floor because he said every 5 minutes. And Randy actually said later that crystallized in his mind the power of that word. The idea that Congress is doing something that they've never done before has a lot of rhetorical force and lets people understand how grave this law is. So in deciding on the book, this was definitely the right title because this was an unprecedented case.
You talk about how the case, well, first the healthcare law itself and the way it was passed, and then the legal challenge as it gathers steam. It creates this sort of constitutional moment in America, and it energizes Tea Party activists. It energizes people on both sides of the debate in terms of talking about the Constitution. So that's not unprecedented in American history, but I mean, you make a very strong argument that is one of these moments that we're going to look back and see that this is when the Constitution and debates about our system are really at the forefront.
Right. I mean, the period from 2009 till 2012 was remarkable because for the first time you had a strong constitutional movement pop up out of nowhere, the Tea Party. This wasn't organized. This wasn't having any kind of a founding cause. It was just people who had a dissatisfaction with the scope of the federal government and their power. And at just the right moment, President Obama gave them their exact gift, Obamacare. And this was like the fuel for their movement. And people weren't objecting to this law purely on policy grounds. I mean, they didn't like it, that it was going to waste money and it was bad policy, but they said, this is unconstitutional. The Constitution does not give Congress this power. And rallying behind Obamacare, their Tea Party grew magnificently. And we saw in 2010, the Republicans gained so many seats in the House, largely in the backs of voting against people who supported Obamacare. And in 2012, it kind of faded away because by that point, the Supreme Court had already upheld the law. So the Obamacare law actually kind of represents a full arc of the rise and slow descent of the Tea Party. I would pause to say that I think that the Tea Party movement is lying dormant. It's lying dormant because the sentiments against this expansion are still existing. It just would require the right trigger to bring it back. And I think one aspect of the Obamacare case is the federal government should be leery about what kinds of exertions they make. People like Nancy Pelosi thought there was no problem with this. When people said, is this constitutional? She said, are you kidding me? I don't think people in the Democrats in particular appreciated how divisive such an issue was, and they paid the price for it. Going forward, I think we'll see Congress maybe not being so keen to pass laws on such a large scale out of fear of what will happen.
Let's talk about the Chief Justice, John Roberts, and his opinion and the arguments or the reasoning that goes into it. And you really have a very thorough discussion. I mean, really of the whole case from every aspect. And it's also I just like to add. I mean, it's an incredibly gripping account. I mean, this is you have a minute by minute breakdown, second by second
like
breakdown
24.
Of that's right, like show 24 of the decision day as it comes down. But the Chief Justice, as we all know, he upheld the law. He sort of formed this coalition with the liberals on the court to do so. But you make this point several times in the book that he rewrote the law. You say he upheld a statute that Congress did not write. I mean, could you explain what do you mean by that?
Okay, so when Obamacare was passed in 2009, we have to remember the president's campaign pledge. In 2008, the president said, I will not raise taxes. That was his pledge. So in framing the Obamacare law, they were very deliberate. The way the Obamacare law works is that if you don't have health insurance, you have to pay this penalty. And the statute called it just that, a penalty. It wasn't called a tax. But as the litigation proceeded, one of the arguments the government used to support it was saying, listen, this is just a tax. We are just taxing people. on not having health insurance. But the statute didn't say that. The statute called it a penalty. It was very clear. So in order for the Chief Justice to uphold the statute, he had like make-believe time, like Mr. Rogers. He said, well, even though it says penalty, we're going to pretend, like make-believe, that it says tax. Because if it said tax, then we could uphold it piece of cake, no problem. So John Roberts, in his opinion, called a saving construction, upheld the law that Congress never wrote. This was a law that Congress could have never passed in 2010, because had they called it a tax, they would have gone slammed at the polls and in the public opinion. This law was passed without calling it a tax, and was upheld by calling it a tax.
The response to the decision, I would group it in sort of two broad categories. There's sort of a political, partisan response. If you like the law, you're happy with the law being upheld. If you didn't like it, you're unhappy about it. But then if you look at the response among legal experts, law professors, legal scholars, it's more complicated, actually a little more interesting, where you had liberal legal academics, very prominent ones, who basically supported the law, thought Congress had the power to enact the individual mandate under the Commerce Clause. They were quite upset with Roberts' ruling because he rejected that argument, and four conservatives did. And then you have sort of libertarian conservative law professors challenging the law. They actually see a sort of a victory for some of their ideas. Let me put it to you this way, are these liberals right to be a little upset at the outcome of the case, and are the libertarians a little right to be cheered by the outcome?
Damon, that's exactly right. When this case first started in 2009, it was a laugher. I talk about in my book how at the 2009 Federal Study Convention in Washington, right here, Randy Barnett, myself, and a few other lawyers were just talking about this case. And at the time, no one thought there was any way the Supreme Court would ever have a single vote, maybe other than Justice Thomas, to strike this down. But fast forward 2.5 years, and this argument gained steam and gained traction and started to be accepted by judges and some scholars. And then we go to the Supreme Court, where 5 justices say that Congress can't regulate inactivity. 7 justices say that the federal government can't coerce states into accepting this Medicaid money. Holy cow. We can put aside what this means for the future and what doctrinally this means, but the court made it very clear that the so-called federalism revolution of the Rehnquist court is still ongoing, and that the court will police the bounds between what the federal government can and cannot do. And this opinion makes very clear that the structural protections of our Constitution, the doctrine of enumerated powers like the Commerce Clause, federalism between the states and the federal government, those matter. And they don't just matter in the abstract. Those are the key bulwarks of protecting our freedoms and our individual liberty. And the fact that you had 5 votes for that, I think, is really significant. And it should represent a shift in the way people approach this. So I said before that perhaps the government might be leery about passing new laws. This should factor into it, because you now have this strong constitutional undercurrent in the people about what the federal government can do. You have the Supreme Court on record saying that there are certain things the government can and can't do. And this actually is not so bad for libertarians. This actually might be a good recognition that the Constitution has very strong libertarian principles embedded into it.
There are still some big challenges in the courts towards the law. What do you make of the prospects of any of those?
So there are a couple lingering challenges. One involves a so-called contraceptive mandate. This law says that employers have to provide contraceptives and abortion procedures to their employees. And the argument goes, well, my business is a Christian business. I run a craft store, and I run it with a Christian virtue where I want all my employees to be devoted to Christ, and it goes against my religious beliefs. Well, it's not really your beliefs, it's the beliefs of your corporation. But the court has held that corporations do have certain constitutional rights. And within the next year, the court will consider one of those cases of whether the government can force a Christian-oriented or Jewish-oriented business to offer these pills or these products. It's a tough call. Another challenge involves the so-called Medicaid exchanges. Because this law was passed so hastily, there are a lot of things that didn't really make sense. And the way the law is written now, if any states decide not to participate in Obamacare, the people in those states are not allowed to get subsidies for the health insurance. HHS said, nah, we're going to do it anyway. And they're probably breaking the law. And those cases should be resolved in the next few months. There are a number of lingering cases, but I think ultimately the Chief Justice's decision saved Obamacare. I'm not too convinced that any of these repeal or defund efforts will work, no matter how many commercials we see for it, because this law is the law of the land. We're kind of stuck with it. That might be a bad thing, might be a good thing, but going forward, I think the lesson we have to take from this is how the constitutional element progressed so quickly and flourished. And when we saw that when the federal government went too far in what they did, the American people clawed back. And I think we will keep that ethos with us going forward as we develop the Constitution in response to the growing power of the federal government.
Thank you very much. Josh Blackman, author of the new book, Unprecedented, The Constitutional Challenge to Obamacare.
Thank you so much, Damon.
Thank you. For Reason Television, I'm Damon Group.